Yeah, good afternoon, everyone. Hoping for a fruitful week for everyone. Welcome to the Intellectual Property in Focus webinar. Thank you, everyone, for being with us here today. I'm Elena May, and with me is Mr. Glenn Vincent Ong, and we will be your hosts this afternoon. We're so excited to share with you the basics of intellectual property. So this event is in partnership with the College of Agriculture and Food Science.
So ayun, good afternoon sa lahat ng ating
mga participants.
So the main objective of this webinar
is to introduce the field of intellectual property among students, faculty, researchers, the different types of IP rights, its importance and relevance to the field of agriculture. So before we officially start our lecture, let's have a quick photo opportunity. So may we request everyone to open their cameras.
Okay, while capturing the window po, a few reminders before we start this webinar. The webinar will be recorded for documentation purposes. Kindly fill out the attendance sheet to be distributed at the start of the webinar. There will be a question and answer session after the lecture, and also only those who will finish the webinar, answer the feedback form, and get 70% at the post-evaluation will be given certificates. And also, keep in mind that this basic webinar etiquette. Mute your microphone to avoid sound feedback. Only ask during the Q&A portion of the webinar. Avoid asking repeated questions. Use the chats to raise your concerns or questions. Use the raise hand option if you want to speak. Stay engaged by using Zoom reactions. And last but not the least, participate and be attentive to the speakers.
So ayun, so ngayon let us call on Dr. Lilia Fernando Corpus for the opening remarks.
Good afternoon, everyone. On behalf of Dr. Elpidio M. Agdisit Jr., the Dean of the College of Agriculture and Food Science, we welcome you to the COPS TTBDO IP in Focus, an Intellectual Property webinar. Intellectual property, or IP, refers to a creation of the human mind, like artistic works and inventions. IP is thus a valuable concept that involves every aspect of the university's roles in teaching, research, and extension work. The creation and dissemination of knowledge is at the heart of every university activity. The challenge is realizing how this knowledge can be best utilized as an asset to provide maximum value to the economy, society, and the university itself. Many universities in the country are now fully aware of how to commercialize the IP arising from their research base. Universities need to be able to create an overall strategy for managing their IP in line with their mission, such as our endeavors and initiatives here in UP Los Baños. It is our hope that through this partnership with the TTBDO, students, staff, faculty, and researchers of COPS will all be equipped with the basic knowledge on intellectual property and understand the importance of technology transfer in bridging the gap between research, extension, and commercialization. Through this two-day webinar, today and on October 23, that will be next Monday, we can encourage students to propose research or thesis topics that are innovative, industrially applicable, and beneficial to the society. Moreover, we hope to assist our faculty, researchers, scientists, and staff to facilitate the IP protection of their works. We are grateful to our research speaker today, Ms. Arian May L. Magistrado, and all our colleagues from the TTBDO, led by their hardworking director, Dr. Emil John C. Cabrera, for the continued partnership in capacity building and promotion of technology transfer in the college. Again, I welcome you all to the day one of the COPS TTBDO IP in Focus, an intellectual property webinar. I hope we all have an engaging discussion.
So ayan, mukhang ready na yung ating mga participants. So to introduce our first speaker, she is a registered chemist, a DOST Accelerated Science and Technology Human Resource Development Program Scholar, and a graduate of Bachelor of Science in Agricultural Chemistry and Master of Science in Environmental Science from the University of the Philippines, Los Baños. She had previous work experiences as a chemistry journal excerptor at a private company, as a University Research Associate 1 in UPLB Biotech, and as Science Research Specialist 2 at IMSP CAS UPLB. She is currently working as a University Extension Associate at UPLB Technology Transfer and Business Development Office under the Intellectual Property Unit. She has experience in university-based intellectual property and technology transfer processes. In addition, she is also a member of Alliance of Tech Transfer Professionals of the Philippines. Let us welcome Arian May L. Magistrado.
Good afternoon, everyone. Can everyone see my screen? So, thumbs up na lang po. So, if we're good to go, okay, good afternoon. I'm Arian Maestrado from the Intellectual Property Unit of the UPLB TTBDO. So, for today, I will be discussing about intellectual property, specifically about copyright, related rights, trademark, and geographical indications. So to start, first let us define what is intellectual property. So intellectual property pertains to any distinct creation or product of the human mind. Of course, by the term property, intellectual properties are protected by so-called intellectual property rights. What are intellectual property rights? Intellectual property rights are exclusive negative rights. Why negative rights? Because if you are the owner of IP, you can exclude anyone from making, using, selling, offering for sale, and distributing your work or invention. Furthermore, by definition, it is a property right. So if it is your property, you have the right to sell, assign, license, or donate your intellectual properties. Also, intellectual property rights are territory specific, which means that it is by country. For example, you protect your IP here in the Philippines. So you filed for example, patent here in the Philippines. If your patent is granted, so the patent is protected here in the Philippines. Also, intellectual property rights are time limited, which means that after a specific period of time, the IP becomes part of the public domain. So anyone can use your invention or your work after it becomes part of the public domain. Also, IPs are fee dependent, which means that when we file for an IP, we need to pay fees, of course, and then to maintain our intellectual property, to maximize the period of protection, we also have to pay maintenance fees. And lastly, intellectual property rights are by first to file rule, which means that the first person to file for a specific IP becomes the first one who has the right for that specific intellectual property right. So we will discuss this further later. So what are the importance of intellectual property rights? So intellectual property rights allows the creator or the inventor to benefit from his or her creation. So it encourages to disclose their IP. How? For example, you have an invention and you file for a patent, and you successfully commercialized your patent. So an industry is interested in your patent. So you can receive royalty fees from the successful commercialization. So it encouraged the inventor to further create something in the future. So in relation to that, it also fosters return on investment and provide incentive for future research. Then, IPRs also contribute to the well-being and development of the society because through IPRs, again, for example, as an patent, inventions are usually patented. So if we see the trend on what IPs are protected, it means that there will be continuous R&D. And through this, it develops the society. And lastly, IPR supports the creation of jobs. For example, you are an inventor and you want to commercialize your own technology. So you build a spin-off company. So you can employ people, thus you create jobs. Here in the Philippines, there's a so-called RA 8293 or the IP Code of the Philippines. So under the IP Code of the Philippines, it states that it is prescribing the intellectual property code and establishes the Intellectual Property Office, which provides for its powers, functions, and purposes. Here in the Philippines, our IP office is the Intellectual Property Office of the Philippines, or the IPO-Phil. Under the RA 8293, here are the types of intellectual property, which we'll be discussing for this lecture. So under this lecture, we will be discussing about copyright and related rights, trademarks and service marks, and geographic indication. And for the second part next week, we will be discussing about patents, utility models, industrial design, layout designs or topographies of integrated circuit, and protection of undisclosed information. Also here in the Philippines, we have a protection for plant varieties, which is RA 9168, or the Plant Variety Protection of the Philippines. To formally start our discussion on IP, let's start with copyright. By definition, copyright is the legal protection extended to the owner of an original and derivative work. Under the Berne Convention of 1886, it covers the literary and artistic works, as well as scientific and scholarly works, and of course, derivative works. What is Berne Convention? So Berne Convention is the oldest convention governing copyright around the world. How is copyright acquired? Works are protected by the sole fact of their creation, irrespective of their mode or form of expression, as well as their content, quality, and purpose. So this means only that protection is automatic from its moment of creation. Ibig sabihin, yung copyrighted work, for example, nag-drawing ako ngayon. So, nag-drawing ako ng flower. Kapag na-drawing ko na siya, meron na agad akong copyright over that. Hindi ko kailangan na mag-file pa nung aking copyright para ma-protect siya. So, the fact na nagawa ko siya, there is already a copyright. What about copyright symbols? So, ito usually nakikita natin sa mga websites or sa books, yung letter C na symbol and yung all rights reserved. So kapag nakakita tayo ng mga symbols na to, it means that the owner of the work retains all rights provided by the copyright law. Ibig sabihin, anyone cannot reproduce, distribute, or adapt any part of the work without your permission. So under the RA 8293, so section 172 of the IP code, ano-ano ba yung mga kasali sa literary and artistic works? We have Class A, books, pamphlets, articles, and other writing. Class B, periodicals and newspaper. Class C, lectures, sermons, addresses, dissertations prepared for oral delivery. Yung letters, so yung mga sinulat na letters, pwede din silang i-protect under copyright. Dramatic or choreographic works or entertainment, pwede din yung makopyright. It's Class E. Class F is for musical composition with or without words. Class G is for works of drawing, painting, architecture, sculpture, engraving, lithography, or other works of art. Also, models or designs for works of art. So, yung mga painting, yung mga sculpture, dito sila sa Class G kasama. Ito naman Class H is original ornamental design or models for articles of manufacture and other works of applied art. So, ano ba yung applied art? So, dito sa example na to, yung design ng mismong cabinet, yun yung applied art. Class I, you can also copyright illustrations, maps, plans, sketches, charts, and three-dimensional works relative to geography, topography, architecture, or science. So kapag naggawa kayo ng mga maps or may mga drawing kayo na related to science or architecture, it is copyrightable. Class J are drawings or plastic works of scientific or technical character. Class K are photos. So this includes photos produced by a process analogous to photography. So any other means, basta nakaka-produce ng photographic works, ay kasama sa Class A. Class L, audiovisual works and cinematographic works. Class M, for pictorial illustrations and advertisements. Class N are for computer programs. Class O are for other literary, scholarly, scientific, and artistic works. So kapag yung category ng work mo hindi nag-fall dun sa mga previous classes na nabanggit, Class O siya. as long as it is copyrightable. Lastly, Class P and Class Q are for sound recordings and broadcast recordings. Ano naman yung tinatawag na derivative work? By the term derivative, so it is a work based on or derived from an already existing copyrighted work. Ibig sabihin, kapag meron ng original work, tapos gumawa ka ng another work na dinerive mo from that or inadapt mo, derivative work ang tawag doon. So derivative works can be protected as new work. So pwede silang magkaroon ng separate copyright provided na hindi nila maaapektuhan yung copyright no original work kung saan sila nag-based. So what are examples of this? So translations of works into different language. Popular example din ng derivative works ay adaptation ng work. So for example, gumawa ka ng film based on a novel or comic. Like itong Avengers, yung original Avengers ay from a comic. Tapos, ginawa nila ng movie. So, yung movie version ng Avengers, yun yung tinatawag na derivative work. Also, arrangements of music. Kapag yung orchestra, plinay nila yung isang original composition na made for a piano. And lastly, compilations of literary and artistic works such as encyclopedias and anthologies. Kung merong mga copyrightable works, ano naman yung mga non-copyrightable works? So definitely, we cannot copyright news or facts. Second, we cannot copyright mere data or discoveries. Administrative or legislative text cannot be copyrighted also, as well as concepts or principles. Lastly, hindi pwedeng i-copyright ang idea. So let's be clear about this. Ideas are not copyrightable, but rather the expression of an idea. So balik tayo sa example kanina. Like, halimbawa naisip ko mag-drawing ngayon ng flower. As long as hindi ko pa siya dinodraw talaga, hindi pwedeng i-copyright yung idea ko lang ng pagdodrawing ng flower. Kailangan ma-drawing ko siya bago magkaroon ng copyright over that drawing. So, who owns the copyright? For original and literary works, of course, ang owner nito ay si author. For works of joint authorship, co-authors shall be co-owners of the copyright unless otherwise stipulated. But for example, if the work consists of parts that can be used separately and the author of each part can be identified, then the author of each part shall own the copyright thereto. For example, merong compilations ng mga articles. So, bawat article, may kanya-kanya silang authors. Kung kaya namang i-distinguish yung author ng each part na yon, ng each article na yon, so pwede silang maging owner of each part. Pero kung hindi, so magiging co-authors sila. For example, on works created by an employee during and in the course of the employment, ang owner ay si employee if the creation of the work is not part of his regular duties, even if he uses the time, facilities, and materials of the employer. So usually to tricky kasi mahirap i-prove. Lalo na kapag yung work mo is, yung ginawa mong copyrighted work is medyo somewhat related dun sa work mo. Parang hirap kasi sabihin na hindi siya part of your work. Pero kapag sobrang ibang-iba, yung copyrighted work na nagawa mo than your usual work, ayun, pwede sigurong masabi na you're the owner. But if the work was created by the employee as part of his regular duties, unless there is an express or implied agreement to the contrary, then si employer yung magiging owner ng work. Pero kahit si employer yung owner ng work, ni-recognize pa rin naman na kung sino yung gumawa, sila yung author. So, meron tayong tawag na authorship, meron din namang ownership. So, sa case na to, this is ownership. Pero, sa case na si employer yung owner, yung mga totoong author pa rin naman, mapapasama pa rin sila. So, ito naman, isang popular case to on copyright ownership. Itong case ni Naruto v. Slater. So, itong nasa picture, siya si Naruto. So, isa siyang Sulawesi crested macaque. Then, noong 2011, nag-take siya ng selfie using an unattended camera of photographer David Slater. So, nasa forest si David Slater, tapos nag-picture siya. Kaso, iniwan niya lang yung camera niya saglit. Tapos, habang hindi niya binabantayan, si Naruto nag-picture gamit yung camera niya. Tapos, nagandahan tong si Slater dun sa mga picture ni Naruto kasi ang cool, selfie siya. So, natuwa si Slater. Ang ginawa niya, nag-publish siya ng book containing yung selfies ni Naruto. Ang nangyari, itong si PETA, nag-file sila ng copyright infringement suit against Slater on behalf of Naruto. Bakit daw? Kasi, hindi copyrighted daw yun. Copyright ni Naruto over that photo kasi siya yung nag-take no photo. So, dapat si Naruto daw yung may-ari. Kaso ang nangyari, dun sa verdict, according sa court, PETA lacked the next friend status to bring the lawsuit on behalf of the monkey. So, yung next friend status, siya yung parang pwedeng mag-represent sa court on behalf of usually, it's a person. Kaya, ang nangyari, dinismiss yung case for lack of standing under the Copyright Act since Naruto is not human. Eventually, ang nangyari pa din is, kahit nanalo si David Slater dun sa case, pumayag siya na i-donate pa rin yung 25% ng future proceeds niya from the use of the selfies to charities protecting crested macaques habitat. So, ang point lang naman nito is, hindi pinapayagan magkaroon ng copyright if hindi siya human, yung gumawa. So, what are the rights protected by copyright? So, pwede natin i-break down yung copyrights into economic right and moral right. Economic rights, meron tayong tatlo. The right of reproduction, right of public performance, broadcasting, and communication to the public and making it available. Also, rights of translation and adaptation. Sa case naman ng moral rights, meron tayong tinatawag na right of attribution and right of integrity. First, dun muna tayo sa economic rights. Economic rights consist of exclusive right to carry out, authorize, or prevent the following acts. So, kapag may economic right ka, meron kang right of reproduction. So, yung nabanggit kaninang tatlo, right of public performance and right of translation and adaptation. Isa-isahin natin. So, yung right of reproduction, you have the right to authorize the distribution of your copyrighted work. Also, right of rental and control importation of your copyrighted works. It also covers yung printing and photocopying of books, reproduction and copying of tape and digital recordings, and covers the storage of works in computer memories and in the cloud and copying of digital files. So basically, ito medyo related bawa sa mga piracy or yung pag-reproduce ng mga copyrighted work. Example na lang, yung mga iniiwan na book sa mga photocopy dun sa labas ng campus. So, kapag kasi ginawa mo yun, nawawalan kasi ng kita dapat yung mga may-ari ng book ang kumikita yung mga photocopyhan. So, dapat controlled yun na hindi mo pwede basta-basta i-reproduce ang isang copyrighted work. Hindi ka rin basta-basta pwedeng mag-save ng mga hindi publicly available. Yung mga pinirata mo lang from the internet. Bawa, may nahanap kang e-book or journal, tapos isa-save mo lang sa computer mo. So, kung may bayad yun, medyo illegal yung paggawa, yung pag-reproduce without permission from the copyright owner. Next is the right of public performance, broadcasting and communication, and making it available to the public. So, ang kino-cover naman ito, basically public distribution of works, rentals, and performing a copyrighted work. So, yung kapag bawa may copyrighted work, tapos pinerform siya bawa sa mga shows, sa mga concert, kailangan merong permission nung copyright owner or merong mga pinasok silang agreement para ma-perform publicly itong mga copyrighted works na to. So, kapag ginawa mo to, pinerform mo on public, pinalabas mo on public without permission from the copyright owner, illegal din yan. And pwede tayong makasuhan. Last is the right of translation and adaptation. So, bago ka makapag-translate or adapt ng isang originally copyrighted work, you must first secure an authorization from the owner of the copyrighted work. And yung owner of copyright in the translation or adaptation. So, ano ba yung translation? Basically, translation is the expression of a language other than that of the original. Yung adaptation naman, modification of a work to create another. So basically, bago mo magawa itong dalawang to, needs permission. So sa copyright, general rule, kailangan mo ng permission. Next naman ay yung moral right. So itong moral rights, this stays with the original author of the work even if economic rights have been transferred or assigned. Di ba dun sa umpisa kanina na mention na yung IPs are property rights. So pwede mo silang i-transfer, i-assign, i-donate. Pero ang pwede mo lang i-assign, i-transfer, i-donate, i-sell ay yung economic rights. So kahit wala na sa iyo yung economic rights mo, you still have your moral rights as the original author of the work. So what is right of attribution? So it is right of authorship or right of paternity. Ibig sabihin, it is your right to claim the status as the author of the work and have your authorship recognized. So ang example nun, you have the right to be mentioned when the work is reproduced. So example na lang, si Shakespeare, matagal na siyang patay. Pero, bawa yung Romeo and Juliet, every time na may mag-adapt ng Romeo and Juliet na work, gagawin nilang movie, na may mention na si Shakespeare yung gumawa ng Romeo and Juliet. So yun yung right of attribution. Whereas yung right of integrity is the right to object your work from being distorted or used in contexts that are prejudicial to the honor and literary and artistic reputation of the author. So for example, may mag-a-adapt nung iyong novel, gagawin niyang film, pero may mga gusto siyang parts na baguhin para mas exciting. So baka gusto niyang dagdagan ng more violent scenes. Ikaw, as the author of the original work, pwede mong pigilan yun kasi baka makasira kasi yun sa image ng original work mo. So feeling mo na di-distort siya and yung context ay hindi aligned dun sa vision mo for your own work. So for the transfer of copyright, as mentioned, economic rights can be assigned or licensed in whole or in part. A transfer, assignment, or license of copyright over a work does not necessarily include a transfer, assignment, or license of the work itself. So, ibig sabihin nun, yung rights lang ang matatransfer, hindi necessarily na yung work. Pero, in the case of moral rights, hindi siya natatransfer. So, these always remain with the original author. However, they can be waived upon writing. So, kailangan may kasulatan na sinasabi ni author na gini-give up niya na yung authorship dun sa work na yun. Kung ayaw niya na talaga. Next are related rights. So itong related rights, kaya siya related rights, related siya sa copyright. These are rights often based on works derived from a work protected by copyright. So baka nalito kayo dun. These are rights neighboring on copyright. So mga types niya ay rights of performers, rights of producers, and the rights of broadcasters. So, isa-isahin din natin. Ano naman yung rights of performers? So, etong rights of performers are rights of those who perform the works, namely the performers, singers, actors, dancers, musicians, and so on. So, let's take for example, a song. So, si composer, gumawa siya ng song. Then, kumuha siya ng singer para i-perform yung song na yon. So, si singer, meron siyang right as the performer. Next naman ay rights of producer. So, rights of producer of phonograms are recognized because their creative, financial, and organizational resources are necessary to make recorded sound available to the public in the form of commercial phonograms. So, balik tayo dun sa example na may original song. And then, si song na kinanta ni singer. So, si singer yung performer. Kung merong studio, recording studio, na nag-produce nung kanta, ginawa niyang album, so, yung recording studio na yun, sila yung may rights as the producer. And usually, producers are the main victims of piracy. So, every time nagpa-pirate tayo ng mga kanta, nagda-download tayo ng movies, ng mga kanta illegally, usually, it's the producers na naaapektuhan. Kasi sila yung may financial investment to make that material public. So kapag dina-download natin illegally yung mga works, so nawawalan sila ng kita. Or bawa wala nang manunood sa sine nung film, wala nang makikinig ng kanta sa mga merong bayad na platforms. And lastly, rights of broadcasters. These are rights derived from their creative and economic input, namely the assembly of programs and on the broadcast signal and its delivery to the audience from the act of broadcasting it. So, balik ulit tayo sa example. So, yung kanta, kinanta ni singer. Then, produce ni producer ni recording studio, naging album. So, tong kanta, kapag play na to sa radyo, tapos na-broadcast na siya to a wider audience, etong si radio station, sila yung may rights of broadcasters. So, basically, sila yung nagbo-broadcast. Meron silang broadcast signal para maparating to sa wider audience. So, what are the purpose of related rights? So this is to protect the people or organization who contributed in bringing or presenting the copyrighted work to the public. Also, it protects those who add creative, technical, or organizational skill to a copyrighted work. So again, balik tayo dun sa example. Yung kanta na ginawa ni composer, hindi naman yun sisikat kung wala yung contribution ni singer, ni producer, at saka ng mga broadcast stations na nagpaparinig ng kantang yun sa public. So each step, meron silang contribution para ma-appreciate natin. So halimbawa yung kanta, kung hindi siya mapaperform ng maganda, hindi din naman yung sisikat. So it adds value to the original copyrighted work. Kaya important na protektahan natin yung rights of performers, producers, and of course yung broadcasters. Ito, another example on related rights. So, nung 1827, papatay si Beethoven. It means na yung lahat ng works niya, part of the public domain na. So, pag public domain na, anyone is free to use his composition. So, then, tong orchestra, nag-decide sila na gamitin yung mga music ni Beethoven, tapos ipi-play nila sa orchestra. So, itong mga sa orchestra, sila yung performers. Then, kung merong recording ng concert, tapos nilagay siya sa CD, produce. So, merong related right, yung orchestra mismo as the performers, and yung nag-produce nung CD na pinapakita yung show na yun. Meron silang related rights. So what is the term of protection for copyright and related rights? In general, it's 50 years. So for artistic, literary, and derivative works, so 50 years after the death of the author. That last surviving author if more than one. So ito yung sinasabi nila na kung gusto nyo na mas matagal yung protection, mas okay pag mas madami kayong author. Or yung mga anak nyo or apo nyo, gawin nyo ding author para matagal yung protection ng copyright. For anonymous or pseudonymous works, 50 years from the first lawful publication. For applied art naman, 50 years then from its creation. Audiovisual works, 50 years also from its publication. Ang naiba lang dito is yung broadcast. So 20 years lang siya from its broadcast. So, saan naman i-register itong ating copyright? So, there are two ways on how to protect our copyright here in the Philippines. Pwedeng mag-apply tayo ng copyright sa National Library or pwede rin naman na sa IPOPHIL. So, si IPOPHIL deputized siya ng National Library to accept copyright deposits. Ano naman yung tinatawag na copyright infringement? So, copyright infringement is the violation of the economic rights granted to the copyright owner or to the owners of related rights. It consists aiding or abating such infringement. Bakit economic rights? Usually kasi, yung economic rights, kung mapapansin nyo, yung economic rights, sila yung mas related sa money. So, medyo monetary yung pinoprotektahan nitong economic rights. So, sa copyright infringement, kapag naapektuhan mo na yung economic right, na-violate mo na yung copyright, economic rights. Kaya siya copyright infringement. So, ito example nito, yun kapag illegally downloading or recording ng mga copyrighted works, yun pumapasok sila sa copyright infringement. Kasi, yung naapektuhan mo na yung economic rights. So, pag nag-illegally download ka ng music or film, hindi ka na manunod sa sine. So, naapektuhan mo na agad yung kita nila. So, a person infringes a right protected when one directly commits an infringement, or two, it benefits from the infringing activity of another person who commits the infringement, and three, kapag meron kang knowledge of the infringing activity which causes or materially contributes to the infringing conduct of the another. So basically, kung ikaw nag-commit, nagbe-benefit ka, or alam mo na may nagko-commit no copyright infringement, pwede ka nang maging copyright infringer din. Ano naman yung tinatawag na fair use? So these are use of copyrighted work, including among others criticism, research, and teaching without the need to get permission from the copyright owner. So di ba kanina sabi natin, as a general rule, kapag copyright, nagpapaalam tayo bago siya gamitin. Pero may tinatawag din tayo kasi fair use. And usually, fair use kapag ito for educational purposes or research purposes, papasok sila sa fair use. Paano ba natin masasabi na yung paggamit natin fair use? So, para malaman natin kung fair use, kailangan natin i-consider yung purpose and character ng use. Una, saan mo ba siya ginamit? Kung for research, private study, criticism, review, news reporting, or education, yung purpose ng paggamit mo, most likely, fair use yon. So ito, halimbawa, itong aking PowerPoint ngayon, ito, fair use siya. Kasi for the educational purposes naman itong paggamit natin. Also, consider natin yung nature of copyrighted work to be used. Paanong nature? So of course, mas mataas ang protection ng unpublished works kaysa published works. Bakit? Kasi unpublished nga sila. Ibig sabihin, hindi mo dapat sila basta-basta na-access. And the fact na kung unpublished work, tas maraming may access, ibig sabihin, most likely, baka illegally nakuha yung copy ng works na yun. Whereas kapag published, so it's publicly available. Also, fair use is easier to justify on works that are factual and less creative compared to works that are imaginative and highly creative works. Paano mga factual? So, kapag yung from educational books, halimbawa ganun, mga information, ayon, mas madaling sabihin na fair use siya. Pero kapag yung mga complicated na works of art, for example, mga painting, ganun, medyo mahirap sabihin na fair use siya. Also, we need to also consider the amount and substantiality of the portions used. Ano ibig sabihin nun? So, yung definition ay short excerpt. Kapag short excerpt siya, kapag hindi siya nagko-constitute more than 10% of the entire copyrighted work. However, if the heart or essence of a work is used, it may not be deemed a fair use. Bawa sa short excerpt, sabihin mo 10%. Pero halimbawa yung heart nung work, wala pa siyang 10%. Pero na-capture mo yung heart or yung mismong essence, bawa yung climax ng story na capture mo, hindi pa rin mo siya masasabi na fair use. Then, yung copies ng short excerpts are provided only to faculty members, administrative staff, and students enrolled in the university who require the copies for educational purposes. So, ito yung sinasabi na pagpa-photocopy. Example, yung pagpa-photocopy. Pwede siguro na magpa-photocopy ka ng few pages for educational purposes. Pero kapag isang buong book na yung finotocopy mo, hindi na siguro yun fair use. Kasi first, it's more than 10%. Tsaka, essentially, hindi ka na bumili ng book, finotocopy mo na lang siya. So what's the difference again of copyright infringement and fair use? So kapag copyright infringement, of course, may na-violate ka na rights of the copyright owner. And it is a punishable offense. So pwede kang makulong, pwede kang magbayad, or pwedeng both. Tapos ang pwedeng mangyari sa'yo ay injunction, cease and desist order, or civil damages. Whereas kapag fair use, strictly for private use. or non-profit, such as education, religious, or charitable institutional use for teaching and research purposes. Yung mga current events reporting and information, fair use din yun. And also kapag government use. So ito, napapanahon, copyright and AI. Pwede bang maging copyright owner ang AI? So based on the US and EU originality test, ang original work, pwede siyang makopyright kapag yung work ay created by a human being. So, ibig sabihin, AI cannot own a copyright kasi wala siyang human authorship. However, i-consider ng US Copyright Office ang isang AI work kapag merong human touch. So, may contribution yung human dun sa final work. Pwede nilang i-grant ng copyright kahit na gawa siya ng AI. So, sa EU, halos ganun din yung sinasabi. Para magkaroon ng copyright, so it should involve intellectual creation of a human author. So, dapat meron siyang attributions ng humans such as personality, free and creative choice, and stamp of the author's personal touch. However, sa UK, pwede. AI can be a copyright owner. So, yung UK 1988 Act allows for authorship and ownership of copyright where there is no human author of the work. Because it's easier to accept that a work originates from a machine which has exercised a modest amount of skill, labor, and judgment. So kung sa UK, ang sinasabi naman nila, bago naman nag-come up yung AI dun sa work, nag-effort din naman siya, parang gano'n. So pwede, kahit walang human author. So let's take this for example. Itong A Recent Entrance to Paradise. So ito yung painting na to. So itong painting na to, actually ano siya, AI generated parang image based from a parang painting. So it's a part of a series depicting a simulated near-death experience. So si algorithm, ang ginawa niya dun sa image, nire-process niya para maging mukhang hallucinatory image. Tapos parang ganyan daw yung nakikita mo kapag nasa afterlife. So, nung final to sa US for a copyright, na-deny. Kasi AI-generated image daw siya. So, walang human authorship. But in this case, so itong comics na to, si Zarya of the Dawn. So itong comic book na to, written by Chris Castanova. Tapos yung illustrations dun sa comic, pinagawa niya kay AI na Midjourney. So noong September 2022, nag-file tong si Castanova ng copyright. Kasi hindi niya sinabi sa Copyright Office na yung image, AI yung gumawa. Nung nalaman yung Copyright Office, ni-revoke nila yung copyright on February 2023. Pero pinaglaban ni Chris Castanova na image lang naman ginawa ni AI. Pero yung flow of the story, yung other things, yun yung creative input niya as the author dun sa comic na yun. So on the same day, na-issuehan pa rin ang copyright tong Zarya of the Dawn, but covering only the expressive material created by the author. So, yung images, hindi sila kasama sa copyright. Pero yung flow ng story, yung arrangements, para makabuo ng isang buong comic, yun yung pinaprotektahan ng copyright. So, ito, dito sa Philippines, nagkaroon recently ng mga copyright issues. So ito pinag-usapan ko, bakit daw na iba yung steps ng tala? So nagka-conflict daw kasi si Sarah at si Teacher Jercel. So kailangan baguhin ni Sarah yung steps ng tala kasi according to Teacher Jercel of GForce, meron siyang copyright over the steps ng tala. So if you're a copyright owner, so you have the rights, pwede mong pigilan from anyone from using that, di ba? As mentioned kanina. So, anong concert, iba na yung steps. Kasi hindi pinayagan ni Teacher Jercel na gamitin yung steps ng tala. Ito namang another case, ito pinag-usapan din to. Yung contestant, gusto niyang sayawin yung gento sa showtime. Kasi sabi ni Vice, bawal na. Kasi naniningil na daw. Bakit? So, again, may economic rights yung mga copyright owner. So, may specific period lang na, bawa, tinatawag nila dun sa mga show, promotion period yata. So, yun, pwedeng i-play yung music or pwedeng i-perform for free. Pero after that certain period, mababayad na sila ng tinatawag nating royalties. Kasi syempre, kailangan nilang kumita. Hindi naman pwede na gagamitin lang natin ang gagamitin yung songs. Kasi hindi makakatanggap ng royalties si copyright owner. Lalo pa dito sa case ng Showtime kasi show sila, kumikita sila. So dapat, since kumikita sila, kailangan nilang magbayad ng royalty dun sa owner ng song ng gento. So, let's skip natin to. Proceed tayo to our next IP, which is yung trademark. Basically, trademark pertains to the legal protection for a mark or brand, which means any visible sign capable of distinguishing the goods or services of an entity. Minsan, may makakita tayo ng TM, minsan makakita tayo ng R. So, ibig sabihin, kapag TM ang nakalagay, it is an unregistered trademark. Whereas kapag yung R, registered na trademark siya. So, bakit daw minsan may TM? Bakit hindi na lang nila i-register yung trademark? Siguro, tanungin natin yun. Minsan kasi, hindi lang naman kasi logos yung pwedeng i-trademark. Minsan, mga phrase, mga word. Bawa, merong product, tapos yung parang slogan nila or phrase, gusto nilang ipa-trademark. Kaso, parang hindi siya trademarkable kasi masyadong generic. Para lang masabi na meron silang ownership over that, naglalagay lang sila ng TM. But if you're intending to file for a trademark, bawa sa inyong logo, huwag niyo lalagyan ng R dun sa mismong logo. Tsaka nyo lang pwedeng gamitin yung R kapag naparegister nyo na siya. So, among all IPs, dito lang sa trademark merong forever. As long as we maintain our trademark. So, trademark has period of protection of 10 years and it can be renewed for periods of 10 years. So, renewable lang siya for periods of 10 years as long as babayaran mo yung maintenance fee. So, what are the purpose of trademark? First, it serves as a source identifier. So, example niyan, may product, may juice. Ang daming juice brand sa supermarket. Kapag alam mo yung brand, alam mo yung mark, alam mo yung product mismo, alam mo kung sino manufacturer. Also, it serves as a differentiator. So again, same brand, different brands ng juice. Para-pareho silang pineapple juice. Pero brand A, brand B, brand C. So makakapili ka kung alin doon yung gusto mong bilhin. Kasi magkakaiba sila. Though pare-pareho silang pineapple juice. It is also an advertising device. Again, o dun sa example natin ng juice sa supermarket, minsan, di ba, binibili natin yung product kasi maganda yung packaging, maganda yung branding, or may product recall. So trademarks can be an effective advertising tool to promote your product. It is also a quality or trust indicator. For example, sa juice ulit, so kung meron ka ng brand na tinatangkilik for many years, subok na subok mo na siya, yun lang yung favorite mong bilhin, yun na yung palaging bibilhin kasi may tiwala ka na dun sa product na yun. And also, trademark hinders unfair competition. Kapag halimbawa may registered trademark ka, tapos may gustong manggaya nung trademark mo, bawa sa juice, yan, si pineapple juice, magkakaiba kayo ng brand. May bagong dating na brand E, nakamukhang kamuka ng logo ni brand A. So, unfair competition yun. Kasi, baka mapagkamalan ng mga consumers na pareho lang si brand A tsaka si brand E. So, if you're registered for your trademark, pwede mong ma-prevent yun. Pwede mong ipaalis sa market yung product ni brand E or papalitan, sabihin mo kasi ginagaya nila yung trademark mo. So what are the examples of a trademark? So trademarks can be word marks. So word marks, words, letters, numerals, names, abbreviations, and the like. So itong popular example nito, to Google and yung just do it na slogan. So, naka-register sila ng trademark. Sa case naman ng sound marks, so sound marks can be jingles or audio. Example nito yung Nokia tune. So, yung tananan, tananan, kung nabutan niyo pa yan. So, yun. Naka-trademark yun. Tsaka yung roar ng lion dun sa MGM. So, yung mga films dati na produced by MGM, yung nag-roar na lion nun, registered sound mark siya. Meron din naman tayong tinatawag na figurative elements. So this pertains to 2 or 3-dimensional marks. So yung 2D mark, so these are made up of words, devices, marks, or their combination visible only on plane of vision. So ito basically yung mga nakikita nating logos or mga trademark, yun lang. Nandun lang sila sa plane of vision. Whereas kapag yung 3D mark, it may consist the packaging of the goods or shape ng goods itself. So ito yung example niya. So ito 2D mark. Basically yung mga logos or yung mga trademark na nakita natin. Ito, tingnan nyo yung Starbucks, merong R. It means it is a registered trademark. 3D marks naman kapag yung shape ng packaging. So, yung old Coca-Cola bottle, yung sexy bottle ng Coke, it is a protected 3D trademark. Tsaka yung lalagyan itong Toblerone, yung triangle na case. Also, mayroon din tayong tinatawag na smell or scent mark. Kapag yung scent, associated siya sa specific product and it acts as its trademark, pwede siyang ma-file for a scent mark. So, itong Play-Doh. So, si Hasbro, describe na nila itong scent nitong Play-Doh. So, distinct yung scent ng Play-Doh. So, yung other clays, hindi pwedeng kaamoy sila ng Play-Doh. Kasi pwede silang makasuhan ng trademark infringement. Also, itong Salon Pass, meron din siyang registered na scent mark. So, yung other medicated patches like this, dapat hindi sila kaamoy ng Salon Pass. Pero, syempre ang menthol kasi nung amoy, so medyo mahirap i-distinguish, but yun, hindi dapat. Also, texture mark, if the feel of a product or its packaging can act as a source identifier. So, example naman natin dito, itong Stevie Wonder in Braille code. So, ayan yun. Yung naka-show dyan. Ginamit nila yan sa pagbenta ng mga merchandise. So, niregister nila yun for a texture mark. So, yan ay naging parang trademark nung merch naman. Meron ding tinatawag na hologram mark. So, if the hologram serves the purpose of a trademark, pwede siyang register for trademark. So, itong hologram for American Express. So, halos lahat ata ng American Express card, merong hologram sa likod. So, yan, naparegister nila for a trademark. Color marks. If the color serves as its source identifier, rather than for decorative purposes lang, pwede siyang ma-register for a color mark. So, itong Milka Purple, registered siya. So, it means yung other chocolate brands, hindi po pwedeng gamitin itong purple ng Milka. Also, itong canary yellow ng Post-it. And ito, very popular. Ang tawag sa kulay nito ay Tiffany Blue. Kasi distinct siya sa Tiffany & Company na brand. So here's a trademark. Meron tayong tinatawag na spectrum of distinctiveness. So ang trademark must be distinct and should not be deceptive. So paano ba natin masasabi? Merong different kind of marks. So 5 sila. Generic, descriptive, suggestive, arbitrary, and fanciful. Yung generic and descriptive, more descriptive sila. So it's a weaker mark. Hindi sila sinasuggest for a trademark. So ano naman yung pwedeng ma-file for a trademark? So mula suggestive hanggang fanciful, kino-consider sila na strong marks because they tend to be more distinct. So ano ba yung generic? So basically generic terms of goods or services being offered by a company. Kaya hindi sila eligible for a trademark protection. Usually, ipapadisclaim yun yung term. Ipapadisclaim lang din sa inyo ni trademark examiner yan. Example, bawa yung Shell na brand, nagbenta sila ng shells. Hindi yun pwede kasi generic. Or yung Apple na brand, pag Apple yung binibenta nila, hindi rin yun pwede. Also, descriptive marks, kapag nagde-describe sila ng ingredient, quality, characteristic, function, feature, purpose, or use of specified goods or services. Hindi rin yun pwedeng i-file for trademark. Bawa, sweet candy. So, yung sweet, descriptive siya. Tapos yung candy, generic siya. So, definitely, hindi yun pwedeng i-file for a trademark. Ipapadisclaim lang yun ni trademark examiner. So, ano yung mga pwedeng ma-file for a trademark? First is yung suggestive. This gives hint at the quality or characteristic of the product without actually describing it. So, ito example is yung Netflix. From the word net, mga paisip ka, internet, online, and Flix related siya sa movies. Which is true. Netflix is a online platform to watch movies. Ito namang Airbus. So, air, something sa air. So, yung bus, baka transportation siya. So, yung Airbus, nagpa-pertain siya sa airplane. So, aerial transportation. Next naman yung arbitrary. Ito naman, words with real-world meaning but has nothing to do with the products or services it offers. So, example ko kanina na Shell. Bakit siya na-file for a trademark? Kasi itong Shell na to, gasoline station siya. Hindi siya nagbebenta ng shells. Also, itong si Apple, ang binibenta niya ay electronic devices. Itong si Dove din. So, si Dove, beauty products yung mga binibenta nila. Pero pag itong si Dove, nagbenta ng Doves, hindi yun pwede. And lastly, the strongest type of trademark are fanciful marks. So these are words that have no meaning at all apart from their function. So other term dito ay coined words or made up names. Yung Adidas, before magkaroon ng Adidas na brand, hindi yan nag-exist. So wala talagang word na Adidas. Same as for Kodak and Pepsi. Bakit siya strongest type of word? Kasi most likely, wala siyang katulad. Unlike dun sa iba na may chance na may maging katulad siya. Or derive siya from words na already existing na. So, pwede dito, halimbawa, gagawa kayong trademark. Halimbawa, paglaruan niyo yung pangalan niyo or combine niyo yung pangalan niyo ng parents niyo, anak niyo, or friends niyo. Ganun. Yun yung fanciful. Meron din tayong tinatawag na collective mark. So, this can only be used by members of the association on which the collective mark is associated. So, this belongs to a group or association of enterprises and pertains to the goods and services offered by that organization. Ang example niyan is yung Rotary International. So si Rotary International, kung makikita niyo sa Philippines, sobrang daming Rotary. So parang bawat province or municipality, meron sila kanya-kanyang Rotary. At pare-pareho sila ng logo. So ibig sabihin, lahat sila under ng Rotary International. So pag hindi ka member ng Rotary International, hindi mo pwedeng gamitin itong mark na to. So dito sa Philippines, example ng collective mark is itong TTS, Tinalak-Tau Cebu Incorporated. So, yung Tinalak-Tau Cebu, isa siyang type of woven fabric. So, hand-woven siya ng women from Lake Cebu. Kaya, yung mga women from Lake Cebu, yung mga gumagawa ng tinalak, nagbuo sila ng parang association. Yun yung Tinalak-Tau Cebu Incorporated. Tapos, yung tinalak na napaproduce nila, protect nila using their collective marks. So, ibig sabihin, pag hindi sila ang nag-produce, hindi siya pwedeng i-brand as tinalak from Lake Cebu. So, association. Next are certification marks. So this can be used by anybody except the proprietor of the mark. And usually, certification marks are used to define standards. And hindi kailangan na may membership, unlike no collective mark. So yung proprietor ng mark, yung nagsacertify ng certification mark and not the user. So it is used to inform public that goods or services meet specific standards required for the use of the mark. So ito yung mga ISO certification, itong mga Philippine Standards mark, so sa mga appliances usually, ICC mark, ito malapit yun na itong nakita. Usually pag Pasko, madami yan sa mga Christmas light. Kasi ini-import natin dyan, Christmas light. So dapat merong certification mark to parang provide siya ng safety na din. So there are specific kinds of trademarks called service mark. So yung service mark, it is any word, name, symbol, device, or any combination used or intended to be used in commerce to identify and distinguish the services of one provider from services provided by others and to indicate the source of the services. So basically, ang sinasabi lang naman itong service mark, trademark din naman siya, except na service yung pinaprovide ng mga gumagamit ng service mark. Unlike kapag trademark na usually products yung ino-offer. So itong FedEx, so courier siya. So, yun yung in-offer niya, service. Kaya siya service mark. So, itong Philippine Airline, of course, airline siya. And itong Amazon.com, it is an e-commerce platform. So, yung common sa kanila, service yung in-offer nila, hindi product. Meron din tayong tinatawag na well-known marks. So, pag yung isang company na-establish niya na yung mark niya, and known na siya worldwide, minsan, kahit hindi nila i-register for a trademark, the fact na sobrang sikat niya, and alam ng lahat na ito na siya, ito yung trademark nun, protected na siya. So, parang hindi mo na kailangan ipa-file for trademark. Like, itong McDonald's, though itong McDonald's registered trademark siya, pero kasama siya sa mga well-known marks kasi known siya around the world. Same as tong Samsung tsaka yung Nike na brand. Regardless kung may active trademarks pa ba sila ngayon or hindi, they are well-known marks na. Kaya, hindi mo din pwede basta-basta gayahin yung mga products na ino-offer nila. Kasi, pwede ka pa rin makasuhan ng trademark infringement. So here in the Philippines, yung trademark registration natin is through iProfil. And online lang yung pag-apply nitong trademark. So you can apply for word marks, figurative marks, so combination of words and figures, and the like. So online lang siya ina-apply. For example, gusto nyo naman i-file, bawa naka-establish kayo ng successful na brand here in the Philippines. So, gusto mo na siyang i-file in many countries. So, paano mo yung gagawin? Meron tinatawag na Madrid system. So, this is a system for international registration of trademarks. So, ang advantage ng Madrid system is cost-effective siya. Kasi through registration lang sa Madrid system, pwedeng ma-protect yung trademark mo in many countries in the world. So, parang single application lang siya, tapos magbabayad ka lang ng fees. So, ma-apply mo na yung trademark mo from in different countries. Of course, it requires application or registration in home IP office before you can file for international application. So, if you want to file trademark through the Madrid system, kailangan mo munang mag-file sa iProfil ng trademark mo before you proceed to your international application ng trademark. So, kung yung mga pwedeng ipa-trademark, ano naman yung hindi? So, first, those that mislead the consumers in relation to geographical indication or origin. So, iba yung protection for that. So, yun yung i-discuss ko later. Second, those that mislead the consumer in relation to the quality or nature of the product or service to which the trademark relates. Kapag nami-mislead yung consumer dun sa mismong product na tinitinda mo. For example, yung example mo kanina na kapag may gumaya ng trademark ng isang product na established na yung trademark nila, ginaya mo. Tapos nagbenta ka ng same product. So, nami-mislead mo si consumer dun sa quality. Baka kasi yun talaga yung gusto nilang bilhin, yung product mo yung kinuha nila. Kasi akala nila the same. Also, those that are contrary to moral or public order, kapag may mga violent elements. So, di ka pwede magpa-trademark ng mga logo sa mga may baril or may mga kutsilyo. Also, you cannot trademark those that consist or contain reproductions or armorial bearings, flags, and other emblems of states party to Paris Convention or World Trade Organization. So flags ng mga bansa or yung mga government emblems, hindi din yun pwede. And lastly, those are official signs and hallmarks indicating control and warranty adopted by them and imitation from heraldic point of view. So, yung mga emblems, halimbawa, yung sa UK, di ba, so yung mga emblems doon, hindi rin yun pwedeng ipa-trademark. Hindi mo siya pwedeng i-incorporate dun sa i-file mo na trademark. So, kung kanina may copyright infringement, meron din naman tayong tinatawag na trademark infringement. So, this is the unauthorized use of a trademark or service mark in connection to the goods or services which may cause confusion, deception, and mistake about the source of goods or services. So So kapag nag-mislead, basically, pwede kang makasuhan ng trademark infringement. So ito, para mas madali natin maintindihan. So let's take, for example, itong mga actual trademark infringement cases. So let's say, for example, itong si Elars Lechon and itong si Elars. Actually, itong si Ellar, yung may-ari ng Elars Lechon, tsaka ng Elars with Z, magkamag-anak sila. So, itong si trademark ng Elars Lechon, maanak sila nung totoo nag-establish nung lechonan business. Tapos, ito namang si Elars, parang maapo sila. So, hindi sila okay sa family. Kaso lechonan yung business nila. Ang kaso, tong si Elars Lechon, nag-file sila ng trademark. So, sila yung unang nag-file for trademark nitong Elars Lechon, tapos itong logo na to, na lechon na nasa bamboo. Then, more recently, may lumabas sa market na Elars. So, nagkasuhan sila. Kinasuhan ni Ellar Foods, itong si MZ Food ng trademark infringement. So, ang naging result nito is, nanalo si Ellar Foods. Kung maalala nyo kanina, sabi natin, di ba, IPs ay by first to file rule. So, si Ellar Foods, so sila yung unang nag-file for the trademark ng Ellars. Kaya, sa kanila greenland. Kasi kahawig daw ng Ellars yung Ellars. Dito naman sa gin ng San Miguel, tsaka yung Ginebra Capitan. So, nanalo dito si Ginebra San Miguel. Kasi katong si Tanduay, sabi nila, yung word na Ginebra, wala daw dapat monopoly or trademark doon si Ginebra San Miguel. Kasi yung Ginebra, generic term daw siya for gin. Kaso, nung sa court, parang nag-survey sila. Dito sa Philippines, kapag sinabi mong Ginebra, na-associate na yon sa Ginebra San Miguel. So, ang nangyari, natalo tong si Ginebra Capitan, naging gin Capitan na lang siya. And ito, tong si McDonald's, nagkaso din siya ng trademark infringement and unfair competition dito kay LC Big Mac Burger kasi yung word daw na Big Mac. Tapos, colorable imitation daw nung logo ni LC Big Mac tong si McDonald's. So, ang haba-haba ng case na to kasi nagsimula sila sa Regional Trial Court, Court of Appeal sila, then ultimately, umabot sa Supreme Court yung case. Kaya, pero ang kinatigan ng Supreme Court is itong si McDonald's. So, meron daw unfair competition and trademark infringement dahil dun sa Big Mac. Kasi magkatunog daw sila. So, dito naman, trademark ownership case is yung sa Itbulaga. Ito just recently. Alam naman natin na nag-aagawan tong Tape Inc. tsaka si TVJ sa ownership ng trademark ng Itbulaga and EB. So, ano ba yung background nito? Yung classification kasi na final na trademark ng Tape Inc. for Itbulaga and EB covers only yung classification na 16, 18, 21, and 25. So, itong mga to, for merchandise. So, ang ginawa nito, nag-file ng ang TVJ with Antonio Tuviera ng panibagong trademark covering 16, 18, 21, 25, plus 41. So, yung 41, para siya sa entertainment. Tapos, nag-file pa ng another trademark itong si Joey De Leon, covering only yung classification ng Itbulaga for, for entertainment. So, ang nangyari, well, na-renew for another 10 years yung trademark ng Itbulaga for Tape Inc. So, ang sabi naman nila, iba kasi yung decision ng Bureau of Trademarks dun sa pending case na cancellation of mark sa Bureau of Legal Affairs ng IPOPHIL. So, wala pa yung conclusion. But for now, ayun, na-renew for another 10 years itong sa Tape Inc. Lastly, dito na tayo sa geographical indication. So unlike trademarks, itong geographical indications is used to specify products na nanggagaling sa specific geographical origin and possess a given quality, reputation, and other characteristics that attribute to that origin. There are two types. So the one is yung indications of source. Ang sinasabi lang nito is nanggaling yung product na yun to that particular location. Whereas yung appellations of origin, GI siya na mas strict yung criteria kasi kailangan yung product may connection yung quality niya and characteristic dun sa geographical environment kung saan siya ginawa or nanggaling and yung technical know-how ng mga taong gumawa or nag-produce sa kanya. So, saan ba pwedeng gamitin yung GI? So, pwede siya sa agricultural products, foodstuff, wines and spirits, handicrafts, and industrial product. Then yung GI, ang purpose nito is to, of course, product differentiators. So, example, na lang natin, so yung Guimaras mangoes. Pag sinabi mong Guimaras mangoes, alam mo na malaki yung mango, tapos matamis. So, iba siya sa mango na naproduce in other countries. Also, GIs contribute to the development ng rural areas. Usually kasi, lalo na kapag yung mga handicrafts or handmade products, usually, mga nag-GI yung mga sa mga tribes, ganun. So, mas mataas yung value ng mga products with GI. So, it contributes to the development ng rural areas. Also, GIs are means to preserve traditional knowledge and traditional cultural expression. So, same dun sa pag mga handmade products. So, yung sa mga tribes, so yung knowledge na yun, napapasa-pasa siya from generation. So, kung may GI, mas mapreserve kasi mas maraming gagawa nun. Ma-maintain yung traditional knowledge. So, as mentioned, this year lang na formalize na yung Guimaras mangoes ay maging first geographical indication here in the Philippines. So, ang description niya na pinasa nila para maging GI si Guimaras mango ay Carabao mango variety, tin-seeded, so yung climate and soil type, and yung practice na ginawa para ma-produce itong Guimaras mangoes. Other examples ng GI ay itong Parmesan cheese from Italy. So, yung true Parmesan cheese ay nanggagaling lang sa Parmigiano region in Italy. So, pag hindi dun galing yung Parmesan cheese, definitely fake yun. Same as yung tequila, it's only from Mexico. And yung champagne, kapag hindi siya galing sa Champagne, France, hindi rin yung totoong champagne. So, that's it for my for the first part of our IP lecture. Thank you very much for listening.
Yan, thank you Ms. Arian for such an insightful discussion. I hope maraming natutunan ng ating mga participants ngayong hapon. And now we are nearing the end of our program. We will proceed to the Q&A portion. For those who have questions, you may type it in our chat box or send via PM.
So, meron po tayong question. So, if magpapa-copyright po ba ng lecture presentation, ang copyright po ba ay per presentation or pwedeng as a whole? Like lecture 1 is separate copyright from lecture 2. Or pwede pong course X lectures as a whole po. Thank you.
Well, for example, di ko sure kung faculty ba yung nagtanong. Pero yes, yung lectures ay copyrightable. Actually, itong presentation ko, copyrightable naman siya. But, for example, faculty ba yung nagtanong? Sa case na lang na yun is, ginagamit kasi natin siya sa class, so pagtuturo. So parang hindi okay na ipa-copyright natin yung lectures natin. If yun, ginagamit natin siya sa pagtuturo. Pero definitely, kung halimbawa na-invite ka na mag-talk, ganun, mag-lecture, pwede mong ipa-copyright, yes. Pwedeng separate copyright for lecture 1, for lecture 2. Pwede naman yan. And pwede din naman siya as a whole. Actually, depende sa'yo kung paano mo siya ipaka-copyright. Pwede namang by parts, pwedeng by whole. Basta as long as when you file for a copyright, same yung like same yung title niya dun sa ipapaka-copyright mo kasi yun yung lalabas sa copyright certificate.
Okay, thank you po Miss Arian for that answer. So from anonymous attendee, kailangan po ba ng business bago magkaroon ng trademark?
Hindi naman. So, yung trade, pero syempre, usually, magkaiba yung business name sa trademark. So, mas okay na kapag may business ka, meron kang trademark, pero hindi naman sila need na sabay. Like, ba mag-file ka ng trademark even before you open your business. Kasi, well, kakailanganin mo din yun. When you file for that, may tinatawag tayong declaration of actual use. So, bakit tayo may declaration of actual use? Para malaman nung IP office na ginagamit mo talaga yung trademark na yun. So, mas okay, nagagamitin mo siya on trade, kaya nga siya trademark. Pero, pwede naman na hindi sila sabay. Hindi naman need na may business ka na bago ka magka-trademark. But it's just that you need a proof na ginagamit mo yung mark na yun in order to file for the actual use. Kasi, ma-forfeit lang din yung trademark mo kapag hindi ka nakapag-provide ng use. Ang purpose kasi of the declaration of actual use is para maalis sa registry yung mga hindi ginagamit na marks. Ma-prevent yung mga nag-hoard ng mark. Kasi, for example, may gusto talagang mag-file ng trademark, nakahawig ng mark na yun, pero hindi niya ma-file kasi may active na trademark. So, kaso kung ikaw gusto mo lang mag-file ng trademark, hindi mo naman gagamitin, na-prevent mo yung others from filing for a similar trademark.
Okay, thank you Miss Arian. So ito naman po, from a student po, pwede ko po ba gamitin yung mga UP trademarks and paano po yung process daw po nun?
For UP trade, case ng UP trademark, so dito sa UP LBTT BDO, tayo nagpa-facilitate ng paggamit ng UP mark. So, hindi basta-basta yung paggamit ng UP marks and you need to seek permission from UP LBTT BDO for the use of these marks. So, you need to file, magkakaroon tayo ng trademark licensing agreement for a certain period para bago nyo magamit yung trademark na yun. And kailangan approve din namin yung design kasi may specific uses for some UP trademark and hindi sila basta-basta pwedeng gamitin lang. And ayun, babayad ng royalty sa paggamit ng UP trademark. So, mag-email lang kayo dito sa UP LBTT BDO. Then, yan, ipa-facilitate namin yung pag-file, yung paggamit nyo ng UP trademarks.
Okay, for the last question po na nag-send, ang tanong po niya ay pareho lang po ba ang counterfeit and trademark infringement?
So, magkaiba yung counterfeit with trademark infringement. Paano sila nagkaiba? So, kanina, as discussed, trademark infringement kapag nagkakos ng confusion or deception dun sa trademark. So, ibig sabihin, kapag confusingly similar yung mark, yun yung trademark infringement. Pero yung counterfeit talaga siya, like fake. So, pag nagbenta ka ng fake Louis Vuitton, so same na same yung itsura, same yung trademark na ginamit mo, yun yung counterfeit good siya. Pero hindi siya trademark infringement.
Ayan, parang may tanong si Ma'am Alma Kanama Salinas.
Hello po.
Hi, Ma'am.
Nakamute po kayo, ma'am.
Hi, Ma'am. Hi, Ma'am Alma. Pwede niyo pong i-type yung tanong niyo.
For others po, you can type in your questions pa po. Meron pa naman po tayong time.
Yan, I think wala ng questions. And now, to officially close the first session of this webinar series, may I call on Mr. Glenn Vincent Ong for the closing message.
So, ayun po. First of all, I would like to thank all of the participants or attendees in this webinar. So, Miss Arian Maestrado discussed about intellectual property as well as different intellectual property rights. Specifically, doon sa copyright, trademark, and geographical indicators. So, na-discuss rin niya yung different mga IPRs as well as yung importance ng IPRs. So, ang mga IPRs ay territory-specific, time-limited, fee-dependent, and first-to-file yung sinusunod. Then, other than that, na-discuss rin yung RA 8293 or the IP Code of the Philippines, which is an act prescribing the Intellectual Property Code and establishing the Intellectual Property Office. Then, under the copyright naman, na-discuss naman ni Ms. Maestrado, yung different literary and artistic works na pwede nating ipa-copyright, as well as na rin yung mga derivative works. Then, other than that, na-discuss rin po ang mga non-copyrightable work, yung mga ownership issues, especially yung example about doon sa macaque na si Naruto versus Slater. Meron rin tayong mga discussions about sa copyright and yung AI. And for the trademarks naman, na-discuss po yung different marks na pwede nating i-apply. So, kasama na doon yung mga suggestive, arbitrary, and fanciful na mga trademarks. And for those marks naman na hindi pwedeng i-apply, nandun yung generic and descriptive. Then, after that, na-discuss yung different trademark infringement cases, katulad ng sa Litsunan, sa Gin Kapitan, and yung sa McDonald's and Big Mac. And lastly, for the geographical indication, na-discuss na ayon, ang mga GI ay pwede for agricultural products, foodstuffs, and other materials. And one of the first GI dito sa Philippines ay yung Guimaras mangoes. So, ayun lamang po. So, thank you po for attending ulit sa ating webinar, and sana maka-attend kayo sa Monday for the second part.
Yan po, and that concludes our webinar. Thank you all for joining us this afternoon. If you want to be updated on our future activities, please like our Facebook page, UPLB Technology Transfer and Business Development Office. You can also email us at ttbdo.uplb@up.edu.ph. Don't forget to fill out the attendance sheet.
A 112 years ago, the UP Board of Regents had a vision to develop their true firstborn college that will spearhead national development through agriculture. At the foot of Mount Makiling, Edwin B. Copeland, together with 7 faculty and 12 students, embarked on the journey to create the UP College of Agriculture, or UPCA. Through its 112 years of existence, the college has produced over 1,000 technologies and variety of plants and animals, 9 national scientists, over 30 outstanding young scientists, and more than 18,000 graduates contributing to agricultural development. UPCA, now College of Agriculture and Food Science, or CAFS, has been continuously contributing to nation building through its instruction, research, and extension function. A mere 10 years after establishment, the college was able to start breeding works with the production of sugarcane varieties with high productivity and resistance to Fiji and mosaic disease. In the 1920s, the importance of agriculture was intensified, and UPCA was recognized as neighboring countries began sending their students to Los Baños because of the high quality of education. In the 1930s, breeds with superior characteristics such as the Burkhala pig, Los Baños Cantonese chicken, and Philippine cattle were developed. The 1960s was a fruitful decade for research. Makapuno, a coconut cultivar often made into a dessert, was pioneered and perfected. Meanwhile, the Dairy Training and Research Institute was the first in the country to freeze buffalo semen, paving the way for artificial insemination of local carabaos. Along with the establishment of UPLB in the 70s, the college received the prestigious Ramon Magsaysay Award for International Understanding, Asia's counterpart for the Nobel Peace Prize. In the same decade, the C4 plants were developed. The soil test kits were produced in support of the Masagana 99 program, and the mango induction technique was introduced. Continuing the production of quality research outputs in the 1980s, techniques to minimize post-harvest losses, the accelerated fish sauce manufacturing process, and the rapid test kit for the detection of pesticide residue